and good morning to everyone. On behalf of the committee, I would like to welcome to this webinar session. For your information, this is part of webinar series organized by Shariah in Built Environment Research Group, SiBE, Southeast Asia Built Environment Research Center, SiBE, Faculty of Architecture, Planning and Surveying, FSPU, in collaboration with Muamalah in Islamic Built Environment, MIBE, Academic of Contemporary Islamic Studies, ASIS, UiTM. Before we proceed, let's start with recitation Ummul Kitab Al-Fatihah. Amin ya Rabbal Alamin. Thank you for spending time visiting to this event. My name is Mohamad Harul Fitri Osman as moderator for this webinar. Today we are so glad to have our honorable speaker, Surveyor Noor Aishah Muhammad Hamdan, to share her research topic in the field of Shariah in built environment. Welcome, Surveyor Noor Aishah.
Thank you for inviting me.
Okay. All right, just a little housekeeping before we start. To all participants, please ensure your microphone in mute mode during presentation to avoid disruption. Should you have any question or comment regarding this topic or this webinar, you may post in Webex chat box. Later, I will pick up and read your question at the end of the presentation. Or you may also unmute your microphone and directly ask the question to the speaker after her presentation. The attendance link will be given in the chat box 15 minutes before the webinar's end. We expect this webinar finish at 11:30. Before we call upon our respective speaker, I would like to give a brief introduction about Surveyor Noor Aishah Muhammad Hamdan. She is a senior lecturer at Center of Study for Quantity Surveying, FSPU, UiTM Cawangan Perak, Seri Iskandar campus. She also a registered consultant quantity surveyor, CQS, with Board of Quantity Surveyors Malaysia, BQSM, and member of Royal Institution of Surveyors Malaysia, RISM. She completed her master degree in Integrated Construction Project Management from UiTM in 2006. Currently, she is undergoing PhD studies in built environment at International Islamic University Malaysia. Her research interests are in the area of construction economics, construction law, and Sharia in built environment. For today's webinar, Surveyor Noor Aishah has chosen a title of Assessment on Ta'wid and Gharamah in Islamic Financing Contract and its applicability potential for construction work contract. Okay, I believe Surveyor Noor Aishah has ready now to start with her presentation. Are you ready, Surveyor Noor Aishah?
Yes.
Okay.
Thank you.
Okay, without further ado, I would like to invite Surveyor Noor Aishah Mohamad Hamdan to deliver her presentation. Over to you.
Okay, terima kasih. Thank you, moderator. Assalamualaikum warahmatullahi taala wabarakatuh. As introduced by the moderator just now, my name is Noor Aishah binti Muhammad Hamdan from the Department of Quantity Surveying, UiTM Seri Iskandar campus. Okay. Actually, this topic is part of my ongoing PhD research. So, I would like to treat this session as more of a sharing session because I'm also a member of SiBE, which is we want to promote our objective at this point is to promote Sharia research in the built environment. So I hope today's sharing would give at least an input for those who are interested to pursue more or to know more about Sharia in built environment. Okay, I'll share my slide. Yeah. Okay, the topic of my presentation today is assessment of ta'wid and gharamah in Islamic financing contracts and its applicability potential for construction works contracts. So because this is part of my ongoing research, these are my supervisors, Associate Professor Dr. Azila Ahmad Zakawi from the Kuliah of Architecture and Environmental Design, International Islamic University, Malaysia. Assistant Professor Dr. Siti Noor Haryati Abdullah Habib, also from KAET, and also Associate Professor Dr. Ahmad Azam Uthman from Ahmad Ibrahim Kuliah of Law, also from IIUM. So this topic has been presented in the Ame Abra International Virtual Conference on Environment Behavior Studies on the 2nd and 3rd of December 2020. And it was published in the EBP, Environment Behavior Proceeding Journal, Volume 5, number 15. So if you're interested to know more about this topic, you can check out the article. However, for today's presentation, I will be slightly different from what I have put in my paper, in a sense that I would like to give a more detailed overview on the relationship between the conventional views and the conventional practices, as well as the Shariah practices, rather than the technical and the methodological aspect of the research. Okay, so today I have 10 subtopics from my outline. So we will start with the overview of late payment of construction works in Malaysia, conventional views on late payment. So what is late payment interest? Shariah issues on interest for late payment. Why Islamic financing contracts as reference? Shariah views on late payment. Then we will focus on ta'with and gharamah in Islamic financing contracts, and Shariah compliant assessment between the conventional practices as well as the Shariah practices, and my recommendations on the applicability potential of ta'with and gharamah for construction works contract, as well as the conclusion. Okay, so for those who are not from the Shariah background, I think mostly are from FSPU here. So because I will explain about ta'with and gharamah later in my presentation, so just to give you an overview, ta'with and gharamah is a form of financial compensation used by Islamic banks and Islamic financial institutions for late payment of financing facilities for the customer. Means that because Islamic banks and Islamic financing institutions, they give loan, right, to customers. So if the customers pays late, so these are the form of financial compensation imposed in the contract by the Islamic banks. So having established that, let's look at the overview of late payment in construction works in Malaysia. So I'm sure everyone have heard about late payment issues in construction works. Not only in Malaysia, it's a problem worldwide. It has been going on, and it has been persistent problem to the construction works in Malaysia and worldwide also, and it has caused massive losses. Companies even have to wind up their businesses due to late payment, because late payment will disrupt cash flow and also give a negative chain effect to all the parties involved in a construction project. So among the headlines in the news, so for example, this news says that slow payments cost the construction industry 64 billion in 2019. So these are recent news. And in Malaysia, Star Media Group awarded late payment interest. So later on, I will explain about the interest which the aggrieved party could claim in the case of late payment. And also companies, because now we are facing the COVID-19 pandemic. Alhamdulillah, we are coming out of it. But companies are using COVID-19 as excuses to delay payment. So this has been quite rampant nowadays. We know that everyone is in difficult financial situations right now, but that should not be used as an excuse to delay payment if it is not a legit, if you do not have a legit reasons. And also because the issues has been so rampant and cause so much negative effects, people are saying, should the regulators start to step in? Because if we see in countries such as in the UK, in the US, Australia, they have a statutory act which enforces the employers or the companies to pay on time. All right. So what are the conventional view on late payment? Because we're talking about construction contract. So when let's put into context, yeah. When we're talking about late payment in the construction industry, it is between the employer and the main contractor. In my case, I focuses on the employer and the main contractor. So when we're talking about late payment here, it is the failure of the employer to disburse the full amount certified to the contractor within the period of honouring certificate. So period of honouring certificate is a period stated in the contract for the employer to pay the contractor after a certification by usually by the architect or the SO. Okay, so this late payment is considered as a breach of contract, but in terms of the category, it is considered as a breach of warranty, which usually does not allow for the contracting parties to terminate the contract. Instead, because of the late payment, the amount due to the contractor will become considered as debt. Okay. So under the law, when you are being when you have a breach of contract, when the other party of the contract does not fulfill your obligation in terms of payment, and you suffer damages under the principles of damages of the common law, referring to the case of Hadley versus Baxendale, the aggrieved party could claim for actual losses, or we call reasonable compensation due to the breach. Okay, so under the law, this also allows for the aggrieved party to receive or to claim for interest on top of the principal amount owed by in this case, the employer. Okay, so let's look at the provision in the construction works contract. In PAM 2018, so just if any of you is not from the construction background, just to give you a highlight, these are four of the main, I would say, main construction contracts used in Malaysia. But the most common contract used is PAM, which is issued by the Persatuan Arkitek Malaysia, as well as PWD. PWD is a contract issued by the Government of Malaysia. So all government contracts will use PWD contracts. Okay, and in Malaysia, client is regarded as the biggest, government is considered as the biggest client or the biggest employer in the construction industry. So in PAM 2018, clause 30.17 states that if the employer does not pay within the period of honouring certificate, the contractor may claim for a simple interest of Maybank base lending rate plus 1. So the rate of the interest is according to the current, or at that particular point, the Maybank base lending rate plus 1%. So for example, if at that time, the Maybank base lending rate is 3%, so 3% say the amount of late payment is 1 million. So 3% out of 1 million, 3% of Maybank BLR plus 1%, so it becomes 4% times the amount of late payment. Okay, in the IEM engineering contract, it states that the contractor could claim for simple interest of 6%. Okay, CIDB 2000, it stated the simple interest of Maybank base lending rate plus 2%, while in the government contract, this provision is not available. So when the contract doesn't have this provision, when late payment happens, we should refer, and the case is referred to the legislation, we the court, we refer to the statutes available. Okay, so in Malaysia, the statutes that are referred to, or the law that are referred to, is the Contract Act. So Section 74, illustration N, has given an explanation on the effect of late payment to the contracting parties, whereby in this case, the aggrieved party could claim for additional amount of payment on top of the principal amount owed by the employer. Okay, in the SIPA, Construction Industry Payment and Adjudication Act 2012, Section 25O, the adjudicator is given a discretionary power to award interest to the aggrieved party, the contractor in this case. In the Malaysian Arbitration Amendment number 2, 2018, in Section 33, the arbitrator is also empowered to award judgment or pre-award interest to the contractor. And Civil Law Act, Section 11, also talks about interest, pre-award interest. Rules of Court Amendment 2018 in Order 42, Rules 12, empowered the judge to give or to award pre-judgment as well as post-judgment. So when I say pre-award or pre-judgment, means that pre-award or pre-judgment refers to the point when the default or late payment happens until the date the case is diputuskan or the a judgment is given by the judge or by the court. And post-judgment refers to after the judgment has been delivered. And also in Limitation Act. So Limitation Act 1953, it deliberates on the period of time or the time period for the, in this case, the contractor to claim for the amount of debt which is owed, the late payment which has become debt owed by the employer to the contractor. So I think everyone is aware of this, but just to be clear, so what is interest? Interest is financial charge on the amount of delayed monetary payment which has become debt as a method of award for damages. So the aim for the award of debt of interest is to put the innocent party in the position he would have been if the contract had been performed. So the issues of interest has been deliberated by the judge in many cases. Some of it are, if we refer to this case, New Acres Sendirian Berhad versus Sri Alam, the judge has stated that it is only fair the interest be awarded against the person who wrongfully deprives another from the use of the latest money. In Nielsen Land Development versus Macro Resources, the judge is the judge is in the opinion that whether a contractor should be entitled to interest for being kept out of the monies due to him for work already done for which he had expended labor, material, financing costs. It is only an argument of law. So the judge also said it is hardly argued against. And in the government of Malaysia, so this is a government project versus Image Warisan Sendirian Berhad, the judge says that interest is awarded to give effect to the bargaining power of the contracting parties and to ensure business efficacy. So here we can see that the award of interest is a common practice in the Malaysian law. And when it comes to late payment in construction industry, if they go to court or any of the alternative dispute resolution, interest usually, and we can say it is part of the claim on top of the additional principal amount. Okay, so why should we look into this matter? So let's look from the perspective of Shariah on the issues of interest for late payment. So this is actually the gist of the research. According to Noman and Alifa, the practice of interest earning based on damages awarded by the judge in court, according to the common law, have a striking resemblance to riba. What is riba? Muhammad Hashim Kamali defines riba as an increase, expansion or excess, addition or growth, and is highly prohibited in Sharia contracts. So basically any additional amount on top of a loan or a debt is considered riba. Imam Al-Shatibi says or deliberated the prohibition of riba gives the effective cause or ilah, which is any excess without a justified compensation. So I would like to highlight here because in a lot of literatures, when we're talking about riba, people talk about oppression, about injustice, which is true. Riba cause injustice, instability in economic transactions, but we should also remember that even if the amount, the additional amount on top of the principal amount, do not hurt the debtor. For example, if I give you a loan, or if I give you a debt of 100,000, for example, and I say to you, on top of the 100,000, you just only have to pay me 20 ringgit. So it becomes 100,000 plus 20 ringgit. It is also considered a riba. Although if we see, the 20 ringgit is not, it's not a big amount of money, but from the perspective of Shariah, it is also considered a riba. So oppression is not the only issue in riba. Any additional amount on top of a loan or on top of a debt is considered as considered as riba. So in the Al-Quran, Surah Al-Baqarah verse 275, it has been, Allah has revealed the munafiqun or the kafir, they say trading is only like usury, riba. However, Allah has made trading lawful and forbidden riba. Okay, so the verse due to prohibition of riba is revealed in stages to our Prophet Muhammad. So this verse is the last verse in revealed to the Prophet in terms of the prohibition of riba. And also, if we refer to, there are many hadith regarding riba, but one of the most famous hadith is narrated by Jabir, which is a companion of the Prophet Muhammad, which said that the Prophet, peace be upon him, sallallahu alaihi wasallam, cursed the acceptor of the riba, its payer, one who records it, and the two witnesses. And he said they are all equal. Means that they are all equal in the eyes of Islam in terms of the sin that they have committed. So if we see this hadith, it reminds us to the hadith or the dalil, which explains about khamar, arak, the alcohol, which also it is stated that one who sells, one who serves, and not only the one who drinks. So it shows the gravity of this what we call this offense in Islam. Okay, why do I choose Islamic financing contracts as my reference? Just to give you a broad overview. So the components of Shariah is basically formed by Aqidah, fiqh, and also akhlaq. So fiqh, the word fiqh means deep understanding. Okay. So under the fiqh, the fiqh section of the Sharia, late payment falls under the law of transaction because we have a transaction between one party with another party. And because it involves a financial transaction, it falls under the category of economic transaction or financial muamalat in Islam. Okay, what is ta'zir? Because here I put a dotted line. So law of crime, in Islam, basically we have three types of punishment, which is hudud, qisas, and the third one is ta'zir. So from my research, after going through all the all the rules and regulations for hudud, I've gone through the rules and regulations for qisas, and then I found that for the case of, or for the issues of late payment, the hukum or the punishment falls under the category of ta'zir. I will explain more about ta'zir later. So also because Malaysia has been acknowledged, is acknowledged as the leader in Islamic economy and finance, not only recently, but according to this news, for 8th consecutive year. So Islamic financing in Malaysia has a well-established structure, a reference, and they have, because all the financing issues in Malaysia is under Bank Negara Malaysia, so they have a proper structure to deal with this issue. So someone who is not, for me, who is someone who has no background in Sharia, I would like to follow the route or the path that has been established, rather than I just go and try to find out from the root of Sharia. I think that would not be suitable for me. Okay, so what are the Sharia view on late payment? So because we're talking about contract, yeah. So in Sharia, contract is we call sacred. You have to fulfill, you have to abide by your contract. So this is revealed by the Al-Quran in Surah Al-Isra. Allah says, and fulfill every covenant, fulfill every promises that you have made to Allah as well as man. So not only your promises to Allah, but also you have to pay very close attention to your promises to men as well. And surely every covenant will be inquired into in the hereafter. Yeah. So in the akhirah. So according to the hadith narrate by the Prophet, which the Prophet has explained four characteristics of an absolute hypocrite. So one of it is whenever he makes a covenant, he proves treacherous, means that he does not stick to his promises. So just now I had mentioned the amount delayed or the breach of contract in terms of late payment would amount the delayed payment as debt. So the amount will be considered as debt. And in Sharia, debt is considered as a very important to be paid. A hadith by the Prophet says that all the sins of a shaheed are forgiven except that. And we know the maqam, the level of shaheed, they can go into paradise, yeah, without much questions in the hereafter. But even the shaheed will be questioned about his debt. Okay, so this is from Sahih Muslim. So in Sharia, because justice is the central issue here, when people do not pay you, you are the aggrieved party. So what can you do? So actually Sharia allows for, we do not call it as you just, allows for late payment charges to be imposed to people who pay late. So in this context, late payment charges can be or could be imposed to employer who pays late to who pays the contractor late later than what has been agreed in the contract. So hadith from the Prophet says that procrastination or delay in paying debts by a wealthy person is injustice. It is considered as injustice. Some of the hadith even use the word tyranny to show the gravity or the seriousness of delaying in terms of paying debt. Okay, and there's also Islamic legal maxim or qawaid fiqhiyah, which says la dara wa la dirar. So this Islamic legal maxim is widely used in determining hukum in Sharia. So it means that neither harming nor reciprocating harm, means that you should do no harm to people, and when harm is imposed on you, you should not reciprocate the harm. And if we refer to the statutes, we can refer to the Sharia resolution in Islamic finance, which deliberates on ta'widh and gharamah or late payment charges due to late payment. We can also refer to istisna policy document. Istisna is equivalent to a construction contract. Istisna basically means manufacturing contract. So if you want a Sharia compliant construction contract per se, you can use istisna as your contract. And also we can refer to the rules of court for post judgment, but the section is order 42 R12A. So the first one for the conventional post judgment interest, the section is order 42 rules 12, but for a Sharia compliant post judgment we refer to 12A. And also AAOIFI is a Sharia standard, international Sharia standard, which is often referred by the Sharia Islamic Council or Sharia Advisory Council in Malaysia when they want to deliberate on the rules, on the Sharia rules. So financial compensation, why? Why is it allowed? Some people might say that it's also equivalent to riba, but why does financial compensation is allowed under the Shariah? So it actually falls under the doctrine of daman. Daman means security or bail or responsibility. You have to bear your responsibility. When you are in contract, you have to abide by the contract. You have to honor your contract. So you have to be responsible of what you have agreed in the contract. So Imam Al-Ghazali defines daman as compensation of restitution of a destroyed property or an infringed right by replacing the like of paying the value. And Imam Al-Shawkani discusses the application of daman to reduce the harm or darar due to deviation of akad. So this fits perfectly into the topic of our discussion today. So deviation of akad means that you do not fulfill your obligation or what you have promised in your akad. Akad means akad lah, your agreement in your contract. Okay, financial compensation for late payment is supported by many contemporary Muslim scholars such as Mustafa Al-Zakar, Sheikh Muhammad Sadiq Al-Darir, Sheikh Abdullah Al-Mani, and even locally, Dr. Zaharuddin Abdul Rahman is also support the form of financial compensation for late payment. However, the fundamental thing to be observed is if you want to impose financial compensation, the amount or the rate of actual of financial compensation must be of actual losses. So it cannot be predictive. You must be able that you must be able to prove that you have actually suffered the losses. So according to Muhammad Abdul Razak. So this leads us to the practice or the imposition of ta'with and gharamah in Islamic financing contract. So as I have mentioned, ta'with and gharamah is a form or is the form of financial compensation used by Islamic bank and Islamic financial institutions to impose or to charge their customer for paying late. So late payment of debt is analogous to ghasb or usurpation, which means that you withheld somebody from using their asset or you withheld somebody from using their property or benefited from their property. So this has the same ilah or effective causes, which is tyrannically obstructing the use of a property and exploiting it. Means that here, why Islam allows for financial compensation is because the Shariah views that when you pay late, you deprive the person who's supposed to receive the money from the benefit or from the benefit of enjoying the money that he should have received. So according to Imam Shafi'i and Imam Hanbali, the benefit of the seized property, in this case late payment, is guaranteed and shall be compensated. So therefore, the Sharia resolution in Islamic finance, second edition 2010, has defined ta'with as compensation for actual losses suffered by the creditor or financier. So in this case, the Islamic banks or Islamic financial institution, due to the delay in payment of financing or debt amount by the customer or debtor. So another form of financial compensation is gharamah. So in comparison to ta'with, which is compensation for actual losses, gharamah is actually a penalty for the delay in financing or debt settlement without the need to prove the actual loss suffered. Okay, so these are the structure underlined by the SSC or Sharia Advisory Council, and we can find this structure in the guidelines on late payment charges for Islamic banking institutions 2012. So this regulatory framework is provided by the Sharia Advisory Council under the purview of the central bank. Okay, so we have three components. So I have mentioned ta'with and gharamah. So the Islamic financial institution or Islamic bank can, in the case of late payment, can impose only ta'with, or it can also impose ta'wid in combination of gharamah. So can it be only gharamah? No. So the basis for financial compensation is ta'wid, but in what case does a gharamah or penalty is imposed to the debtor or to the customer? So in the case that the customer uh, deliberately or intentionally delays the payment and repetitively. So it just to show that the debtor is a repetitive uh, offender, or can we say offender, and also he does it deliberately. Okay. But the amount of the combination rate charge is a limit is limited. So you cannot just put any rate that you like. Okay. So what is the maximum combined rate? This is actually different according to the product, because Islamic bank, they have a lot of product. They have the murabaha, they have ijara, they have istisna. So each of these product, they have their own maximum rate if ta'wid and gharamah to be imposed, should be imposed to the customer. So the justification of imposing gharamah together in combination with ta'wid is actually to increase the efficacy of late payment charge in avoiding financial defaults. Okay. All right. So these are the principles of ta'wid underlined by the guideline. So in determining the compensation rate of actual losses, some rules should be observed. Number one, the actual loss to be compensated from any default payment from the date of payment, which the default happened, until the maturity date shall be not more than 1% per annum, only 1%. So maturity date refers to the financing period. So for example, your financing period is 7 years. So the maturity date is at the end of the 7 year. So if you default any payment within the 7 year, the cumulative amount should not be more than 1% per annum. Okay, so only a small portion of it. And then the actual loss to be compensated from default payment which exceeded the maturity, means that after the financing period has ended, shall be referred to the prevailing daily overnight Islamic interbank rate on the outstanding balance, subjected to IBRA. IBRA is rebate of the Islamic financial product. And the reference rate for the actual loss shall be determined at the point of default when it happens, computed on a monthly basis, so it is not compounding. And the ta'wid earned, so here the Islamic banks can keep the amount of ta'wid or the amount of compensation imposed to the customer as an income to the bank. Okay, while gharamah, the calculation of gharamah is the difference between the combined rate, the limit that I have just said just now, minus ta'wid. Okay, so for example, if the combined rate is 4%, then ta'wid is 1%, means that your gharamah will be 4 minus 1, will be 3%. So gharamah is imposed as a means of deterrent for defaulters against delay in repayment or defaults. Okay, so because you can see that the rate of ta'wid is only 1%. So some of the people, they say only 1%, it doesn't hurt me. So they keep on repeating the delayed payment. So the bank come up with, okay, if this continues to happen, we might impose penalty to you. Okay, Shariah does not allow gharamah to be recognized as a source of income because we want to penalize, because actually we want to teach the debtor, we want to teach the customer, the Islamic bank wants to teach their customer not to repeat the offense or not to delay the payment intentionally. So they cannot consider the amount collected from the customer from gharamah as an income. Instead, the amount must be channeled to charitable organizations. Okay, so the IBI, there are rules where they have to define, they have to record the gharamah, and any income to the IBI shall be deemed non-Sharia. If the bank keep the proceed from gharamah as an income, it will be non-Sharia compliant. So what is the purpose of gharamah? And it must be done very, very carefully. The aim is to instill discipline amongst debtor in making timely payment. Again, careful considerations must be given in the computation of these charges to avoid riba. Okay, so I have done a comparison between the ta'widh and gharamah in Islamic financing contracts with interest for late payment in Malaysian works contract, the provision of interest. So I have come up with 7 themes to do the comparison. First is in terms of the rate. For ta'widh, it is only for actual losses, means that you have to prove the actual losses. But gharamah, there's a calculation for it, which is maximum combined rate minus the rate of ta'widh, which is 1%. That is your rate for gharamah. But for construction works, the interest for late payment is not based on actual losses if it is predetermined in the contract. So like what I have shown you in PAM, in IEM, or in CIDB contract, the rate is already been predetermined. But for PWD, because there's no provision for interest, so we should refer to the law. So law, again, I have stated just now, all the statutes that allow for the award of interest in case of late payment. And penalty is not practiced in our construction works. So in terms of the compliance, this determination of rate for interest for late payment in construction works contract is considered non-compliance to the Shariah. Formula, similar, non-compounding. Assessment, compensation can be taken as income for Islamic financing. Penalty cannot be taken as income and should be distributed to charitable organisation, while interest for late payment can also be considered as income. So this is similar. So limitation for quantum. Ta'widh is prescribed rate by the SAC. So currently the prescribed rate is 1%. But if the Islamic bank or financial institution feels that their losses is more than 1%, they can write and apply to the SAC, Shariah Advisory Council, to change the rate. But they have to prove that their losses is more than 1%. Where does 1% comes from? So it is according to their deliberation, the SAC deliberation. So maximum combined rate, so I have mentioned this before, capped at a prescribed rate, not more than the conventional interest. So just now we have looked at it should be referred to the IMM, Islamic market rate, and also not exceeding 100% of the outstanding principal amount for combined charges. While for the conventional practice, not more than the stipulated contractual rate or through statute post-judgment. Currently, the post-judgment interest awarded by the court is 5% for post-judgment. So any award for the pre-judgment by practice should not be more than 5%. So usually the judge will award around 4%. According to my research, usually the judge will impose a 3 to 4% pre-award interest rate for the case of late payment. Okay, so calculation, charge per annum calculated at the point of default, similar, so comply. Duration expressly stated from the point of default until payment is made in full, same, similar in our construction. And classification of defaulters. For ta'widh and gharamah, the Islamic bank only impose the penalty for ta'widh. Ideally, it is only imposed for intentional defaulters. But for our construction industry, we do not care about the classification. As long as the employer pays late, we consider that as late payment and we can bring the matter into legislation. So in that case, it does not comply to the Shariah. Okay, so these are the similarities and differences. So we can see the differences in terms of the rate, no penalty practice, and also no classification of defaulters. Okay, so we come out to my recommendation for the applicability potential of ta'widh and gharamah for construction works contract. So recommendation number 1, so because determination of actual losses is very fundamental in determining ta'widh or using ta'widh as a financial compensation. So I would suggest that the contracting parties, the main contractor and also the employer, at least have an estimated list of actual financial losses. Because we have been doing the project so many times, actually the contractor and also the employer, they actually have in mind, they can estimate what are the losses that they would suffer in case late payment happens. So, and this list should be mutually agreed by the contractor and employer during the formation of contract. For genuine defaulters, for employer who, there are many reasons why employer pays late. So the contractor should give a discretionary rate or discretionary measure in calculating for takwid or rate for late payment charges. And only for developers who have temporary financial problems. Okay, for international debtor, I would suggest that the rate would would consist of direct as well as indirect costs. Well, this is allowed under the Shariah. For example, the Shariah Committee of Araji Bank allows for this, and under the common law, Robinson versus Hamdan case also deliberated about the direct and consequential losses of damages. But according to Azman and Muhammad Nasir, and also under the principles of damages according to Hadley and Baxendale, we should only consider uh, losses which are remote to the cost of damages and not opportunity cost. So amount of cumulative late payment charges, I would suggest that would not exceed the principal amount, because if the payment has been going on for so long, the rate might add up and be more than the principal amount. Okay, the dalil which supports this is from Al-Baqarah verse 188, which says, do not eat up one another's property among yourselves by false means, unjustly. Means that everything that you claim, that you have lost due to the late payment must be legit. And nor give bribery to the judges, so that you may knowingly eat up a part of the property of others sinfully. Okay, so we must be clear, our conscience must be clear. We only want to claim for actual losses that we have suffered due to the late payment. Recommendation number 2, introduction of penalty, because like I have shown, there's no practice of penalty in our construction contract. So penalty, we have a clause of penalty in our Malaysian contract, section 75, and the recent judgment in the case of Cubic Electronics Sdn Bhd and Mass Telecommunications Sdn Bhd has changed the way we see, the common law sees penalty, whereby now the judge has the judge is in using the principle that if you have a reasonable reason, then penalty can be imposed. So for intentional defaulter, like I mentioned, as a mean of penalizing the offense, we could also include the indirect cost in the calculation of penalty. So indirect cost can be a basis of penalty. And also, if this case is brought to the judge can use discretion. So this is where ta'zir comes into the picture. Because I have mentioned in Shariah, we have 3 types of punishment: hudud, qisas, and also ta'zir. So ta'zir is actually a discretionary measure by the judge. So the type of punishment under ta'zir for financial compensation or financial penalty is called al-gharamah wal musadarah, which is fines and seizure of property. So actually there are other ways of penalizing the late payers, but because we're talking about financial compensation, so fine of financial fine is a form of penalty that according to my research is suitable for this kind of situation. The aim of takzir is to reform the offender, so to avoid them to repeat the offense, the satisfaction of the victim, and the deterrence of the public from committing similar acts. So we can see that the issues of late payment is rampant. So it happens almost in every project, and it has become, even in some research, it is reported that it has become a culture in our construction industry. So when it becomes a culture, so everybody is like, oh, it's okay paying late, only 10 days, only 20 days. Yeah? But it is not okay, because you have to abide by your contract. Okay, and also in determining the rate of penalty, we have to have a balanced approach. Must be impactful for them to not to repeat the offense, but not to be overburdened to the late payers. And proceeds from the penalty, because it cannot be considered as income, can be channeled to CIDB or Construction Industry Development Board for construction related training programs or modules. All right, and recommendation number 3, and my final recommendation, is classification of defaulters. So I think there should be a classification of employer who intentionally pays late. So under the Shariah, this is called musir, or solvent debtor, which they have the capacity to pay, but they intentionally pays late. And if they have genuine reasons why they cannot pay on time, they should be able to provide evidences for deliberation. Islam pays high attention to those having genuine financial difficulties in paying their debt. So there are other categories actually in Sharia, which is Musir, insolvent debtor, which they do not have enough asset to pay. And also another category which is called Muta'asir, which debtor who are having temporary financial constraint. So this is highlighted in papers by Aznan Abdullah, Atika Abdullah, Professor Madya Dr. Aznan, Professor Madya Dr. Atikullah Abdullah, and also it has also been mentioned in ISRA research paper. So in the Al-Quran also calls for this discretion by the creditor when the debtor are having a hard time to pay. So in Surah Al-Baqarah verse 280, Allah says, but if the debtor is in a hard time, grant him a delay until he can pay his debt. But of course, we have to have a framework to ensure that, the reasons are genuine. How long can we allow for the debt to continue, and so on. Therefore, late payment charges under the guidelines are only imposed on intentional, I would suggest for intentional or solvent defaulters with reasonable circumstances for delaying payments. Okay, so in conclusion, my recommendations, I believe, have proved that there are high potential applicability of ta'widh and gharamah to be harmonized with the current practice. And this is beneficial for Muslims, especially for Muslims involved in the construction sector as an employer as well as a contractor, because it can improve our worldly affairs, and our main intention is to gain Allah's blessing. And for non-Muslim, it would benefit from more transparent terms of contract and a more stringent approach or repercussion for employers who intentionally pay late. Thank you.
All right. Thank you for interesting and informative presentation, Seri Noor Aishah. As for me, there are so many terms in sense of financial, law and Sharia principle, which I cannot digest all of that just in 1 hour session. Uh, what I just know from the presentation, there is a provision in Sharia for additional charge for late payment. However, the person who suffered the damage should prove their loss, the actual loss. Okay, now we open for Q&A session. Right, to all participants, if you have any question, you can unmute your microphone and directly ask to the speaker, or you can post your question in the WebEx chat box. Okay, I invite any question from participant. Okay, here we just got a few comment from Madam Haja. This is a good presentation. Thank you. Okay, from Madam Ain Ismail. Thank you, Sebagai Aishah, for great sharing.
I hope my presentation is clear enough for everyone to understand. Please, I welcome your comment or questions.
All right. There is a attendance link post in the Webex chat box, so all the participant can take attendance from the link. Okay, comment from Dr. Mohamad Arif. Good sharing session. Many thanks, very Aishah. Okay, great sharing, great knowledge for me from Madam Kumarasari. Okay, for your information, this webinar session will be recorded and will be posted in SiBE website. So you are invited to visit the SiBE website to get the previous webinar series. And if you want to know further about this research group, you also invited to visit the website.
Assalamualaikum, Mr. Chairman. Can I say a few words, please? My name is Khairul
Yes.
Rashid.
Yes, please.
Right. Congratulations, Sebagai Aishah. Very good presentation. I have no question, no comment. I would like to engage you with a brief discussion with regards to what you have done. In your presentation, start with Gharamah, you are taking a position. The engagement is between a bank and a customer. Yeah. So Islamic financial institution, the bank provided loans and the customer borrowed money from the bank. So the context is quite clear because the Islamic financial institution exists for a business. Yeah. And the customer, people like me can afford to acquire property, for example, I borrowed money. Okay, so that is a different story altogether, but that is the context of what you have done. However, in the context of the construction industry, the situation is rather different because here the role of the bank appears to be taken up by the contractor. Yeah, because it is actually the contractor who have got to put forward the money first before he get paid, isn't it? And the employer or the developer becomes, in this instance, the customer. If we apply that analogy between the arrangement between the bank and the customer and the contractor and the employer, yeah, the contractor exists not his line of business to offer loans. So if that context is understood, have you considered what would be the arrangement instead of the things that you did in relation to the principle of Ta'with and Gharamah? Because the roles are not exactly the same. Wallahu a'lam. I mean, as I say, it's not a question, it's not a comment. I have no issues with what you have presented, but I would like you to explain or engage me in the discussion because actually the scenario are not similar. Yeah, bank and customer, as well as contractor and employer, their situations are not the same.
Yes, correct. Okay. Okay, thank you, Prof. Okay, Alhamdulillah. All right. So in this situation, that's why before I go into Ta'with and Gharamah, I try to put into context the agreement or the contract between the employer and the main contractor. Okay, so first we have established that the main contractor and the employer has a contract, And in the contract, there are terms which highlights on the period and the procedures of how payment is to be received by the main contractor. So before I go directly into Ta'wid and Gharamah, I have also mentioned about financial compensation from the view of the Shariah. So before we adopt Ta'wid and Gharamah, first we have to look into, is financial compensation applicable or allowable in Shariah? So after looking at the evidences, the discussion, so actually financial compensation can occur also due to the breach of contract. In this case, I have mentioned deviation of akad just now. Okay, so the first thing that we have established that there are contract, the contract has been breached or the terms of contract has been breached, and losses must occur. We must be able to prove that losses has occurred. So in terms of your question, what are the relationship? Because before we go into depth, you mentioned between the financier and the customer, yeah, they are in the business of giving loan. So when loan are not paid accordingly, it becomes debt. So I try to take the situation in similar context to the construction, where we have a contract. The contract has been, the terms of payment has been breached in the contract. Losses has occurred. Okay, when losses has occurred, actual losses has occurred. So in terms of the money owed, because you mentioned just now, the contractor used their money first. They have done the work, they have executed their part of the contract, and then they should be paid accordingly. So in this case, we try to take the context of debt from the financial institution versus the customer to the money owed by the employer with the main contractor. So the issue here, I understand that the situation is different, but we can see in terms of the, can I say, kias? We have the same situation. We can kiaskan the situation where contract has been breached, money is in question, the money has become debt. So the situation is similar with in our construction industry, whereby we have a contract has been breached and money is in the question, because I mean money is in the question as debt. So in addition to the money owed, losses has happened. So I think, is that acceptable? my explanation, or
Well,
do you think that?
as I said earlier on, it is not a question or a comment, it is
Mhm.
a discussion. So I am not in a position to say whether it is appropriate or not, but it's just that looking at the context, you see. So because when a bank loan a money to a customer, whereby this Ta'wid and Gharamah basis that you're using at the moment, yeah. So when a bank and a customer enter into a contract, that is based on loan payment arrangement. So the contract is on a loan, one of the SiBE, you see. Where
Yes.
here
That's
the context between the contractor and the employer, to me, again, people can challenge me and I'm not sure I'm right or not, yeah. But here, the relationship between the contractor and the employer is different, because
yes.
contractor is not in the business of loaning money to customer. They have an agreement, yeah, that the contractor will do the work and he will get paid. So perhaps the contract is more like buying and selling of goods kind of contract, rather than bank and customer borrowing money. You know, so perhaps
Yes,
that could be
understood.
an area that should be explored instead.
Yeah.
However, in the context of istisna, yeah, when the contractor failed to deliver the project on time, they are allowed to be charged liquidated and sustained damages, and it is allowed in istisna on condition that the provision is provided at the beginning of contract.
Yes.
In the istisna, again, expert can correct me here. I'm probably not sure whether I'm right or wrong, but in the context of the istisna, liquidated and extended damages is allowed if both parties agree, and the actual amount need to be proved. So the context here is that when the contractor fails to deliver on time, he is in breach. Therefore, the compensation is the LAD, which is pre-agreed at the beginning of the contract, but the actual amount needs to be proven. So would you not want to consider a question of breach, therefore leading to compensation, rather than automatically borrowing the idea that is being used by the Islamic financial institution? Because there is
Understood.
here, because the context is entirely different. If I'm what you call a customer here, or I'm the contractor for that matter, in the context of your arrangement, yeah, I will not want to agree, because now you are assuming my position as if I'm in the business of loaning money to people, but I'm not. In fact, I borrowed money from others so that I can put forward this work, and therefore I claim my money back so that I can service all my other loans. So I'm not rich as if I'm the bank, you see. So my
Yes.
position is entirely different altogether.
Mm-hmm.
I stop there because I'm only bringing into the discussion the context leading to your Taqwid and Gharamah. I have no question on Taqwid and Gharamah because those are legit within the context of the Shariah. Yeah, but it is the environment within which you come up with your solution to the late payment issue, taking or making a short circuit assumption that the contractor exists as if he is a financial institution loaning money to people, but their roles are not the same. So that should also be looked into. Wallahu alam. Thank you very much.
Thank you, Prof. Yeah, probably I was not very clear about, because it requires further deliberation in terms of the breach of contract and how the Sharia views it. So nevertheless, I appreciate your comment and will make sure that I will be clearer next time. Thank you, Prof. Assalamualaikum.
Assalamualaikum.
Waalaikumsalam.
Aisyah,
Yeah,
saya ada dua question nak tanya.
Dr.
One question.
Suhana, is it? Oh, okay.
Yeah, okay. One question about in this study only focusing in late payment only, or include underpayment and non-payment? Because when we talk about payment problems, it consists of, normally industry talk about three types of payment.
Yes.
Late payment, underpayment, and non-payment, which is non-payment auto dispute. And then, when we talk about the issue, payment issue, which is considered late payment and underpayment. So in this research, is covered only for late payment, or also
Late, sorry,
second one, the diagram, which is the variable, if not mistaken. Okay, the slide. Boleh tak tengok yang slide? Ada variables, yang ada 3 section tu.
Sekejap ya. Ada lagi tak? Can you see? Boleh nampak tak moderator?
Tak.
Okay, sekejap. I stop sharing first. Okay, ada
Okay, so the diagram.
Sekejap. This one.
No. The slide 16.
Okay.
Number 6. Okay. So how you integrate how you integrate these differences, similarities and differences, how to read this
Okay, actually this is from this table.
means macam mana you nak integrate from from conventional and Islamic, right? This variable. So how you integrate from two different, one conventional and then one more from Islamic context. Thank you.
Okay, thank you. Okay, for the first question, yes, we're talking about late payment ni. In terms of the literature, we always talk about yang paling selalu is non-payment lah kan, non-payment and underpayment. So actually my research only focuses on late payment. However, if the amount certified is not paid in full, the balance payment is also considered as delayed. So I would say it also consider underpayment as well, because the amount which is not paid in full can be conceived as debt, and it also falls into this context lah of late payment. Okay, the second one, this diagram actually is derived from this table. So as you can see here, I've made assessment on, okay, what are the, basically what are the items or provision in the construction contract related to interest, related to interest of payment or late payment, in terms of the compliance to the Shariah. So from this, kalau kita nampak ni, non-comply in terms of the rate and also the classification of defaulters. So ada dua major yang glaring lah, ya. So daripada sini sebenarnya I try to put into context banyak yang kita similar daripada kita differences. So yang tadi in terms of rate tu, so rate I try to ni differentiate lah. Yang ini kalau kita punya Malaysian construction contract, kita pakai rate of interest. We refer to the commercial rate of interest. Commercial rate of interest ni kalau tengok tadi kan dia banyak refer kepada Maybank based lending rate, ataupun kita refer kepada what are agreed in the contract lah. Contohnya dalam IEM dia kata 6%. And then it is only in the form of compensation without penalty. So compensation ni kalau basically it's a compensation lah. Tujuan kita bukan untuk penalize. And then itulah classification of defaulter tak ada kan. Tapi dari segi kalau Islamic, rate of ta'widh ni dia mesti actual losses suffered and proven. And kalau macam yang kita kata tadi, macam saya tunjuk Islamic financing contract kan, dia pakai 1%. So 1% tu mana datang, memanglah dia agree juga dalam kontrak, tapi it's a deliberation by the SAC. Maksudnya Shariah Advisory Council, dia dah deliberate. So not the bank themselves. So kira deliberation ataupun guideline daripada Shariah Advisory Council. So after they have calculated everything, they say okay, the rate yang suitable kalau ada late payment is 1%. Tetapi dalam Islam juga kita allow for, kita tak nak repetitive offences tu, which yang ini tidak kita kata tak ada approach dalam kita punya conventional procedure. Kita tak ada approach macam mana kita nak deter these recurring issues ni. Okay, especially in our contract lah, tak ada say kan. So that's why I say dalam Syariah dia ada konsep Gharamah, which is actually a penalty, dan juga yang ini tadilah classification of defaulter. So kalau dalam Syariah ni sebenarnya dia pay attention kepada sama ada you mampu ke you tak mampu bayar, you sengaja ke you tak sengaja, where this is absent lah dalam kita punya practice. I hope that answers. So basically to answer ini datang daripada sinilah. Or how to integrate ke? Does that answer your question, or you want to know how to integrate?
Okay. From maknanya siapa? Who's yang kata non-comply? You make a decision or you validate the statement? Who said because the red one, the slide number 15 kan?
Okay. So actually this apa kita kata team ni, I dah go through dengan expert lah. So expert kalau nak kata non-comply tu, I go through dengan expert from the Shariah lah. So those who are involved dengan Islamic financing lah.
Thank you.
Thank you.
Okay, thank you. There is one comment and question from Associate Professor Mohamad Fisal Ishaq. Assalamualaikum everybody, good session. However, I think it is quite difficult to contractually identify intentionally or unintentional defaulter, and who would certify this?
Okay. Betul lah, memang kan. Everyone would claim they are unintentional. So even if we look at most literature pun, banyaknya membincangkan tentang sebab-sebab kenapa berlakunya late payment kan. So dia ada management ke documentation issue. So actually there are many things lah yang boleh menyebabkan late payment ni. Tapi if we look contoh practice di UK lah contohnya. Kalau kita refer kepada Construction Act di UK. So they have a time frame actually daripada tarikh dia keluarkan sertifikat. Kemudian actually in the ACTA, Construction Act in the UK, they actually allow for a time if the employer feels that they don't want to pay ataupun they have reasons why they don't want to pay or they cannot pay or whatnot, they have a time and they have to prove. And dia kena bagi evidences why they cannot or why they don't want to pay. Similarly sebenarnya dalam IEM punya kontrak ada provision yang membolehkan sekiranya employer merasakan bahawa amount certified by the engineer is not agreed upon, so dia kena bagi tahu 7 days before the final date of the payment. So di situ isu dia adalah evidence lah. But having said that, di Malaysia ni kita tidak ada satu statutory yang menetapkan bahawa you have to do this. Tapi kalau di luar negara, contoh kalau saya ambil Construction Act tadi, dia memang di bawah apa kita kata undang-undang dia, di bawah Construction Act tersebut, you have to. If you don't provide evidences and you do not pay according to the time allocated, you are considered as late payers lah. So kalau di UK, once you pay late, they have a statutory, kita dinamakan sebagai interest. Sorry, lupa pula. Interest statutory interest on debt. Maksudnya apabila you tak bayar pada tarikh yang ditetapkan dan you tidak ada apa-apa notice, you tidak ada beri apa-apa evidence yang menyatakan you tak mampu ke, you have a genuine reason why you are not paying fully the amount certified, you automatically considered as late payer. So the amount that you do not pay automatically considered as debt. Dan di UK dia ada statutory rate for interest on debt which is Bank of England base lending rate plus 8%. So dekat negara maju lah, Australia pun tak silap saya. So macam UK memang ada. Jadi di Malaysia kita hanya ada provision sahaja. Dan to answer your question, yes it is difficult. So that's why by having this provision, bila kita pergi kepada court, inilah asas yang akan di-refer lah oleh court dan you can deliberate your reasons there lah. So the judge yang akan so kalau macam saya tadi, saya cadangkan the rate is different between intentional and unintentional defaulter. So of course bila kita tidak ada apa-apa statutory yang clear on that, bagaimana prosedur dia, it depends on the judge lah. So to answer your question, who would certify this? It would be the judge lah. It will be under the discretion of the judge according to the evidence lah. Di Malaysia pun walaupun kita dah ada provision ni dalam kita punya kontrak, rate of interest ni dia bukannya automatic. Still you have to go to court ke ADR ke untuk claim. Kalau kontraktor nak claim kan interest ni, they have to go to court. So there is where all the evidences are presented lah. Boleh ke PM Fisal? Okay ke? Saya masih belajar lagi, sila komen.
Okay.
Okay, Alhamdulillah. Terima kasih.
Can I join the discussion with regards to this late payment? I think in the context of the PAM form, for example, we have this statement about period of honouring certificate, isn't it?
Yes.
So if the client or rather the employer fail to pay within what is stated as the period of honouring certificate, that is the starting point for this discussion on late payment, I think. Of course,
yes.
The final say can be very complicated, even leading to the matter being brought to the court. But for the purpose of discussion, the starting point, in my opinion, is when the employer failed to honour payment during the period of honouring certificate. That will
Yes.
keep the situation simple.
Yes.
But I would like to go back to what I've said earlier on, because while listening to the discussion you had with Dr. Siti, Suhana, and is it PM Faisal? I cannot get the name. I quickly look into some references here with regards to the context of what is appear to be similar to construction. So in the commodity market, for example, they have got this contract whereby people buy and sell, and to make sure that payments are being made on time. So they practice what appears to be a kind of deferred payment, a kind of deferred payment. Say, if I were to buy that commodity, I agree to pay within the next 30 days, for example. As long as I didn't put the date fixed in advance, because that will be gharar, But if I say, okay, I will pay within 30 days, for example, so that is sufficient in order to make it in compliance with the Shariah. So that concept is called by mu'ajjal, It's a kind of deferred payment, but it is called by mu'ajjal. So in this context, so if I buy a commodity from you, for example, and I can be doing it as often, or I can make an agreement to pay you in installment, So the arrangement is between a buyer and seller, It is not like your context between a financial institution and a person who borrowed money from that financial institution. So I'm putting the analogy as if the contractor and the employer is like a buyer and a seller. So the client or the employer buys the product from the contractor upon the contractor's successful completion of a certain portion of the work as certified by the architect. Okay. So the context of by muajal is valid if the two parties agree for payment to be made sometime in the future, but no specific date, otherwise it becomes ambiguous. However, the context of the idea on how to make this contract work in case the buyer failed to pay or failed to pay on time, somehow they didn't bring in the concept of tadwith and gharamah. What they do in order to make sure that people honor their contract, of course, other than the requirements in Islam, is that either the buyer will come up with a collateral, so that in the event that the buyer failed to pay, that is collateral there to ensure that payment is being made, or a promissory note. And in the event that the buyer could not pay, a kind of compensation ought to be paid to the owner, and that money then cannot be used by him, but will have to be channeled to charity after deducting expenses, I think. So the point I'm making here, perhaps, again, I mean, of course, you deal with your supervisors and the team, but perhaps you may want to look into this other aspect so that it enrich your study. So that if you like, all areas have been catered for, and you come to conclusion, yes, ta'with and gharamah arrangement between a financial institution and a customer borrowing money is the best approach in order to settle this issue. Although I contend herein that the context appears to be not quite similar. Wallahu alam.
Thank you, Prof. We take that into consideration and deliberation with my supervisors. Thank you. Of course, we should look at all routes available. Understand?
Right, thank you. Maybe there is one final question from the participant before I close this Q&A session. Okay, no question. So Alhamdulillah, we have come to the end of this webinar session. Again, we would like to say thank you to our speaker for sharing the informative talk, and thank you to all the participants for allocating your time for this webinar. Before we end up this webinar, let's close with the recitation of Surah Al-As and Tasbih Kifarah. Bismillahirrahmanirrahim. Wal-As innal insana lafi khusr illa allazina amanu wa amilus solihati wa tawassaw bis sabr. Subhanakallahumma wa bihamdika asyhadu an la ilaha illa anta astaghfiruka. Okay, see you until next time. Inshallah. Assalamualaikum.
Thank you, everyone. Alhamdulillah.